All right, let's dive into a really critical and honestly an often overlooked part of the EU's new AI rulebook. We're talking about Article 110. Now, this might sound like a dry legal reference, but it's actually the key that unlocks a whole new era of AI accountability. And just so you know, this analysis was carried out under the scientific supervision of Professor Vihar Kiskinov. So, as you probably know, the EU has just written the world's first ever comprehensive rulebook for artificial intelligence. It's a huge deal. The whole goal here is to build a market for AI that's trustworthy, that's human-centric, basically an AI ecosystem that puts people first. And let's be real, the ambition is for this to become the global standard. But here's the thing. Rules are only as strong as their enforcement, right? So what happens when things go wrong? When a biased algorithm denies thousands of people a loan, or some manipulative AI starts causing real harm to its users? How can ordinary people actually fight back and get a remedy? That's the big question, this enforcement gap that we're going to tackle. Okay, so to really get to the bottom of this, we've got a roadmap. First, we'll look at the AI rulebook itself. Then we'll check out Europe's collective lawsuit engine. It's a powerhouse. After that, we'll see how Article 110 acts as the critical link between them. We'll put it all into the bigger picture of accountability, and finally, we'll talk about what this new reality actually means. All right, Section 1, the EU's AI rulebook. Let's start with the foundation. The most important thing to get here is that this isn't just a friendly set of guidelines. No, its entire structure is built with legal action in mind. It's designed to create crystal clear, actionable duties for companies. So the core logic of the Act is this risk-based pyramid. Think of it like this. At the very top, you have things that are an unacceptable risk, like government social scoring. Those are just banned outright. Done. Below that, you have a high-risk AI. We're talking about systems used for hiring or deciding if you get a loan. These face super strict rules. Then you've got another level for things like chatbots, where the main risk is about transparency. You have to know you're talking to an AI. It's this clear, tiered system that lays the groundwork for legal action. And the stakes for breaking these rules, they are massive. We're talking about fines of up to 35 million euros, or even 7% of a company's global turnover. That's a huge number. This is what we call public enforcement. It's all about punishing the company. But, and this is a really big but, those massive fines go to the state, not to the victims. Think about that. The company gets punished, but the thousands of people who were actually harmed, they get nothing. This creates what lawyers call a civil liability gap. The system says a wrong was done, but it doesn't actually help the people who were wronged. So how do we fill that gap? Well, this brings us to the second piece of our puzzle. It's a different but incredibly powerful legal tool called the Representative Actions Directive, or RAD for short. You can pretty much think of it as Europe's engine for class action-style lawsuits. Now, this engine is driven by groups called qualified entities, or QEs. And these aren't just any old law firms. They are specially designated nonprofits. Think consumer protection groups or digital rights advocates like the famous privacy group NOYB. They're essentially expert watchdogs with the technical and legal chops to sue on behalf of all of us. And this is where it gets really interesting. You see, the EU has deliberately created a dual enforcement system. You've got two tracks running in parallel. On one side, you have the regulators hitting companies with fines. Their goal, punishment. On the other side, you have these qualified entities filing lawsuits. Their goal, to get injunctions, to make the bad practice stop, and to get compensation for consumers. It's about making the victims whole. Two different goals, one system of accountability. So, this brings us to the big reveal, the critical link. We have the AI Act's rules on one hand and this powerful collective lawsuit engine on the other. But how do you connect them? The answer lies in one small but game-changing provision, Article 110. What Article 110 does is actually pretty simple, but its effect is profound. It just adds the entire AI Act to the list of laws that can be enforced through that Representative Actions Directive. And you have to understand, this wasn't an accident. It was a huge win for consumer groups who fought for it, specifically to plug that liability gap and give citizens real power. Okay, so what does this look like in the real world? Let's run through a few scenarios. Scenario 1. Imagine a social media platform using a manipulative algorithm that's causing psychological harm to teenagers. That's a prohibited practice. A qualified entity could sue to get that algorithm shut down and get compensation for all the kids affected. Or how about this? A company is using a high-risk AI for hiring, and it's systematically discriminating against women and minorities. A QE could file a lawsuit across multiple countries, representing thousands of people, and demand compensation for all those lost job opportunities.
And it's not just about software. Think about an autonomous car. If its AI doesn't meet the Act's strict standards for robustness and accuracy, and it causes accidents, a QE could sue the carmaker on behalf of every owner for property damage or even minor injuries.
It even covers things like transparency. Let's say a news website is pushing out deep-fake articles, but failing to label them as AI-generated. A digital rights group could sue them for what's called informational harm, forcing them to add labels and maybe even getting small damages for everyone who was misled.
Now, it's really important to understand that Article 110 doesn't work in isolation. It's one crucial piece of a much larger, interconnected web of EU laws, a whole ecosystem designed to tackle AI harm.
This table really helps map it all out. You've got the AI Act combined with the RAD, which we've been talking about. That's for collective action when a company breaks the rules. But that works right alongside things like GDPR, which covers data privacy harms, and other new laws coming for individual lawsuits when a product is defective. The key takeaway? A single AI screw-up could trigger lawsuits from multiple different angles at once. So what's the bottom line here? We're entering a completely new reality. The way all these laws are coming together, it marks the start of a brand new era for AI accountability in Europe. So, if you're a business, this means you need a new game plan, a litigation-ready strategy. And this isn't about being scared, it's about being smart. It's the blueprint for building AI people can actually trust. That means building compliance in from day one, keeping meticulous records like they're your legal shield, talking to these consumer and digital rights groups before there's a problem, and of course, checking your contracts and insurance to make sure you're covered. And really, it all comes down to this powerful idea. The era of AI accountability has arrived and will be enforced not only by regulators, but by collective actions in courtrooms across the Union. That dual-track system, that changes everything.
Which leaves us with one final big question to think about. By connecting the world's toughest AI rules to one of the most powerful tools for collective lawsuits, has the EU actually created the global blueprint for how we hold AI accountable from now on?